So I'll continue to present the speakers in the next panel, and it's my pleasure to present first the Associate Professor Diana Marcheva, who is a professor at New Bulgarian University and at Constitutional Law and a fellow and an ally of the community, but also a person who is deeply involved with the topic of human rights in Bulgaria, Liana. Then Radoslav Stoyanov, who is a co-chair of Bulgarian Helsinki Committee, but also of LGBTI organization Действие, and who has long years of practice as a human rights defender. And Adam Bruton, the representative of the Council of Europe, who traveled all the way from Strasbourg to be here with us today. Well, thank you, and I'm going to be your moderator, so come. So I saved some of my time to present you, but I will start with Adam Bruton, who is policy advisor at the SOGIEST unit at the Council of Europe, and who is currently based, comes from the UK, but he's currently based in Strasbourg and works for the Council of Europe. And Adam will focus on the obligations of the member states of the Council of Europe regarding the implementation of the judgments of the European Court of Human Rights, the role of the Committee of Ministers, the mutual cooperation between the Council of Europe and the member states, and how the reluctance of member states to implement the judgments could be overcome. So please, Adam, if you can start.
First of all, thank you very much to Desvia. Is that the correct pronunciation? I've learned that today. Thank you so much for the invitation to speak at this really important event. So as mentioned, I work in the SOGIEST unit at the Council of Europe. We work on ensuring the human rights, dignity, and equality of LGBTI persons in Europe. To briefly introduce the Council of Europe, for those that don't know, it's an intergovernmental political organization formed of 46 member states. Founded in 1949, the Council of Europe's work is underpinned by three main values: human rights, democracy, and the rule of law. The European Convention on Human Rights, which I'll continue to refer to as the Convention, is one of the key legally binding instruments of the Council of Europe. All 46 member states are parties to the Convention, and new members must ratify it. To explain a little bit about the functioning of the European Court of Human Rights, it's the court of last instance for complaints of violations of the rights enumerated in the Convention by the member states of the Council of Europe. Applicants to the court are individuals who make their claim on a violation of the complained rights by the relevant signatory state and who have exhausted domestic remedies. However, the finding of a violation of the Convention by the court is not the last stage, as that judgment must then be executed. The member state in question proposes individual measures to ensure restitutio in interregnum, which basically means putting the applicants to the extent possible in a position in which they would have been had the requirements of the Convention not been disregarded. Additionally, where applicable, the member state can propose what they plan to do to prevent similar violations. These are known as general measures. The general measures can take a variety of forms, not only legislative reform, but also awareness raising and the training of officials. Otherwise, an assessment of the situation can be made, and the Committee of Ministers, with the support of the Department for the Execution of Judgments, can adopt decisions on whether more or other individual or general measures are necessary. The Committee of Ministers, supported by the Department for the Execution of Judgments, then monitors the execution of that judgment, following the action plan provided by the concerned member state, and decides on whether the measures implemented are sufficient to close the case. Throughout this process, civil society organizations can send Rule 9 submissions to the Committee of Ministers to provide their feedback on how the execution process is going, feeding really well-needed expertise into the decision-making process. Member states can, and sometimes do, sometimes are called upon within the decisions of the Committee of Ministers, use the support of my unit, the SOGIESC unit, in the Council of Europe to complete that execution. The SOGIESC unit has expertise and resources to provide, for instance, legal opinions, or support the drafting of legislation and policies, assist with capacity building of authorities, and awareness raising. I'll quickly move on to the court's jurisprudence in relation to same-sex partnership recognition and legal gender recognition, considering the judgments quoted in the blurb of this panel, and show how these judgments have affected change. Then I'll explain how, through the Council of Europe's bodies, those individual state judgments can help create Europe-wide standards, which then feed back into the court's decision-making. So the court made clear in Valiantos and Greece in Valiantos versus Greece in 2013 that the applicants, a same-sex couple, were in a comparable situation to different sex couples as regards their need for legal recognition and protection of their relationship. Then, in 2015, in Oliari and others versus Italy, the court ruled that in the absence of marriage, same-sex couples have a particular interest in obtaining the option of entering into a form of civil union or registered partnership. It's worth underlining at this point that since these judgments, Greece has implemented, first of all, registered partnerships and recently marriage equality, and Italy has introduced civil unions. More recently, the court has issued a number of cases in a similar vein, which have triggered concrete steps towards legal recognition for same-sex couples. For example, in Malka and Malka versus Ukraine, parliamentarians have taken steps to introduce draft laws on registered partnerships, which are yet to be adopted by the parliament. The SOGIESC unit has supported these efforts by providing a legal opinion on one of these draft laws. On legal gender recognition, since the 2002 court decision in Christine Goodwin versus the UK, which we heard about earlier, the court established the principle of the necessity of recognition of gender identity. The jurisprudence has since evolved as to the quality of that recognition process. For instance, in X and Y versus Romania, the court found a violation of the convention because the legal gender recognition process was not quick, transparent, and accessible. The court has also ruled on how legal gender recognition cannot be subject to any sterilization requirements. In both instances of same-sex partnership recognition and legal gender recognition, soft law standards established by the Council of Europe, meaning soft law meaning that they're not legally binding per se on the member states like the convention, these have actually influenced court judgments. The 2010-5 Committee of Ministers recommendation on combating discrimination on the grounds of sexual orientation and gender identity, adopted by all member states of the Council of Europe, is itself inspired by court jurisprudence. It provides a policy roadmap for member states to ensure the quality of LGBT persons in their jurisdictions. This recommendation calls on member states to adopt legislation making provision for registered partnerships. This provision of the recommendation was then quoted in the earlier mentioned Oliari case as part of the court's reasoning. According to the third comprehensive review of the 2010 recommendation, which was developed by the SOGIESC unit and taken note of by the Committee of Ministers, 22 member states have implemented marriage equality, an increase of 9 from the previous review, and 22 member states have registered partnership regimes, an increase of 14. In 2015, the Parliamentary Assembly of the Council of Europe issued a resolution on discrimination against transgender people in Europe, as well as pushing member states to step up efforts on combating discrimination against persons on the grounds of their gender identity. It also called for them to establish legal gender recognitions that are quick, transparent, and accessible, and based on self-determination. Some of this wording is quoted in the already mentioned X and Y versus Romania case on legal gender recognition. To date, a total of 12 member states have implemented a self-determination model for legal gender recognition that is quick, transparent, and accessible, and a further 20 have some form of procedure, although not meeting the mark of this best practice. The importance of the jurisprudence of the court cannot be overstated, both for effecting change in those involved member states, but also developing Council of Europe standards. It relies on strategic litigation in member states, and this strategic litigation must meet the requirements of the European Court of Human Rights to be accepted and then adjudicated on. And I know that Distivia provides a lot of expertise in that area, and so it's extremely important for the civil society involvement there. I'll leave it there for now, and then
You caught me unprepared. I was making notes. Thank you, Adam. I will directly jump and give the word to Associate Professor at Constitutional Law, Diana Marcheva, who, except being a constitutional law scholar, academic lecturer, author of academic works in the field of constitutional law and rule of law, but she especially focuses her work on human rights. And actually for this panel today, she specifically researched quite a while on the implementation and the existing mechanisms in place in Bulgaria, and how our institutions, namely the Ministry of Justice, is creating or is not creating working mechanisms in order for these judgments to be, to allow these judgments to be implemented without further delay. Diana, please.
Thank you, Danisa. So I will start with quite a bold statement that Bulgaria lacks an adequate institutional mechanisms for the implementation of the Strasbourg Court decisions. And I will actually address these mechanisms which were created over the past 15 years in Bulgaria and presented to the Council of Europe to demonstrate the political will of the government to improve the process of implementation. One of these mechanisms is actually the annual summary report delivered by the Minister of Justice and presented from the government, the Council of Ministers, to the Parliament. So we have this mechanism which was created in 2012 to demonstrate that actually the Parliament will be notified of what measures, legislative measures need to be taken in order to implement the decisions in the cases of general measures needed to be taken. So how this mechanism works in practice, how it functions. I made a research right before this conference to see what happens to these annual reports duly registered each year since 2013. Only 2 of the reports of 2016 and 2017 actually underwent the parliamentary procedure which is necessary for each such report, so that to have a discussion on the report on the level of a parliamentary commission and then in the plenary session. Only 2 of those reports actually were formally accepted by the Parliament. All the remainder, all the last reports ever since, actually are registered in the Parliament, distributed to the Parliamentary Commission of Legal Issues and Human Rights, and they reach a dead end there. No discussion is made. They are not included in the agenda of either the parliamentary commissions or the plenary sessions. And even and it proves that the mechanism is actually a facade for a general measure being taken for the implementation of the decision, because it doesn't work even on a formal procedural level when you make a check what actually happens. And even in these two reports, which were which had a debate at the level of the parliamentary commissions, when you read the report from the parliamentary commission, you see that no meaningful debate took place. That actually the MPs were asking questions to educate themselves what all this is about. And even the few one or two questions which specifically concentrated on Neshkov, on some of the cases, were did not generate a debate, but were just passed formally to pretend of being discussed on a parliamentary level. But even this doesn't take place over the last almost 10 years. We'll see what will happen with the last report, which was registered this year at the end of September, because I notified one of the MPs who is at these commissions, and she promised to ask for it to be taken into the agenda. But this actually demonstrates how a mechanism could be hollow, could not be even formally and procedurally implemented, although it is demonstrated to the Council of Europe as one, actually ensuring that the Parliament would address the issues. And this is the first issue in the institutional framework. The second one is related to the legislative process itself. In 2016, the legislative process underwent a reform in which all the draft laws, all the bills presented to the Parliament from the government needed to have an ECHR compliance review. And this was presented as a guarantee that before a law becomes a law, actually the Parliament would have this evaluation regarding the compliance with the Convention and the case law of the European Court of Human Rights. However, a loophole was created because not only the Council of Ministers, but also the members of Parliament could actually present laws to the Parliament. And such requirement was not for this evaluation, for this compliance review, was not mandated for the draft laws presented by the MPs. And exactly this gap which in my opinion was deliberately left in the law, this gap led to all these horrible examples, like the ban on the LGBTI propaganda in the Preschool and School Education Act last year in Bulgaria, and it is reproducing itself again and again on all kinds of draft laws presented by the members of Parliament. If the members of Parliament are not required to present laws in conformity with the Convention, and they're not required by law, actually the mechanism at the end is created in a way to not to function this compliance review made by the Ministry of Justice. And the last one, the last mechanism I will address. This will be all the efforts made by the Ministry of Justice and the Directorate for Legal Representation and before the European Court of Human Rights. The truth is, the people working there, the administration is has been working on the issue of implementation for over a decade, and they actually led projects to strengthen the national capacity for the implementation, collaborating with NGOs, the academics, and all the stakeholders. However, all these efforts appear unsystematic and project-based. When the project actually ends, we cannot see such efforts. And another issue is that one of these projects ended with a proposal for creation of a national coordination mechanism for the implementation of the European Convention of Human Rights. However, to be drafted as a secondary legislation by the Council of Ministers. However, such a mechanism already exists regarding human rights in general, except the implementation. And even without such secondary legislation, the Council of Ministers is obliged by the Constitution to coordinate the efforts of all these experts in the government. They need such a regulation drafted by themselves only to demonstrate political will and not to create tangible and practical results, because even without such a regulation, they should do that. And this, in my opinion, demonstrates again the lack of will, not only political will, but the lack of will to create a real institutional mechanism. Because institutions should be impersonal and supra-individuals, above individuals. They should work independently of the political parties and who actually implements these mechanisms. And in Bulgaria, they are not created in this way, in my humble opinion. And I think my time is getting to the end. I said the three main issues I wanted to raise, and that actually lead me to the conclusion that with which I started, that Bulgaria actually lacks the institutional mechanism for implementation of the judgments of the European Court of Human Rights against Bulgaria. Thank you very much.
Thank you, Diana. I guess Radoslav Stoyanov, as a representative of the Bulgarian Helsinki Committee, will continue what Diana started, because the Bulgarian Helsinki Committee recently, yeah, I can say it, okay, recently executed a report, study on the implementation of the European Court of Human Rights judgments in Bulgaria. And when we say that Bulgaria is not implementing Kuyova and Babukova versus Bulgaria and PH versus Bulgaria, it's not only that Bulgaria is not implementing these judgments that consider the rights of our community, but Bulgaria has a serious, deeply rooted problem, which can be said to be also a political problem, on the implementation of judgment. So, Radoslav?
Thank you. Dear guests, we are here in this room today because Republic of Bulgaria promised to observe the European Convention of Human Rights. Bulgaria chose to declare itself bound with the convention. As a consequence, we are here. And I'm here today to talk about what happens when Bulgaria does not keep its promise, and more specifically, how can we gently push Bulgaria so that it does keep its promise. Unlike European Union, Council of Europe, a whole different international organization, does not have among its weapons financial sanctions or financial benefits to withdraw from naughty member states who violate their obligations. So coercion as means of securing enforcement of law is not really an option here. We are left with voluntary observance of law. Bulgaria pursuit of a positive international image, for example, to be seen as trustworthy and predictable when making promises. In mid-2024, which is recently, the Bulgarian Housing Committee, one of the organizations that I'm co-chair of, together with ЛГБТИ действия, analyzed implementation of judgments of the European Court of Human Rights between years 2013 and 2023. We looked into official data, interviews with government officials, analysis of Council of Europe, and national reports. In 2023, 166 cases were pending execution, which is one of the highest rates per capita among Council of Europe member states. 52% of pending cases were leading cases, and 37% of these cases were under the enhanced supervision procedure. Some 24 cases had been pending for more than 10 years, and 27 for 5 to 10 years. Average execution times often exceeded 5 to 8 years for leading or enhanced supervision cases. Although Bulgaria has reformed certain areas following Strasbourg Court's judgments, for example, reforms on prison conditions and on trial length, many systemic problems remain unresolved, including those concerning judicial independence, accountability of prosecutor's office, and minority rights. What happens when Strasbourg judgment is delivered against Bulgaria? On Council of Europe's side, case goes to Council of Ministers and supervision begins. On Bulgarian side, the case goes to Directorate Procedural Representation of the Republic of Bulgaria before European Court of Human Rights, or DPR. Within the Ministry of Justice is this department. This internal structure of the ministry acts as both Bulgaria's legal agent before the European Court of Human Rights and the National Coordination Authority for execution of judgments. Although it has formal responsibilities to propose measures, translate judgments, and prepare reports, its institutional status is low, limiting its influence. It cannot independently propose legislative or budgetary changes. These must go through Minister of Justice or the Council of Ministers for approval and are sent to Parliament to be voted on by people who were in no way involved in the often complex issues of each and any case in need of execution, as we just heard from Professor Marcheva. At the time, the DPR had 12 staff members, all civil servants, handling both litigation and execution work. The team lacks adequate funding, administrative support, and training. Salaries are below average for the public sector, and there is no regular training or exchange with other member states. Despite this, the team works with dedication, producing annual reports and maintaining a public database of judgments and translations. Execution of the European Court's judgments in Bulgaria relies on a patchwork of instruments, government ordinances, parliamentary decisions, and internal ministry rules, rather than a single clear law. Judgments are not directly enforceable domestically, save for legal provisions in procedural law regarding reopening cases. Payments of compensation require a decision of the Council of Ministers for each case. While all public institutions are bound to observe the convention, like local authorities, for example, they often fail to respond to DPR's request and to voluntarily participate or aid execution efforts. This makes the process slow and bureaucratic. Currently, there is no dedicated parliamentary committee to monitor the execution of the judgments. Furthermore, as we saw in the beginning of 2025, pursuing populist political gains, Parliament is skeptical to openly defying European Court of Human Rights and introducing and adopting legislation aimed at preventing the execution of some judgments on topics considered controversial, like registration and operation of more than one Eastern Christian Orthodox Church. As we saw in 2021 in its famous decision 15 on how concept of sex in the constitution should be interpreted, Bulgaria's constitutional court is as well prone to omitting the parts of European Court of Human Rights case law that does not fit into populist agenda of the day. Bulgaria cooperates regularly with the Department for the Execution of Judgments, including technical missions and consultations. However, the DPR's participation in international meetings, including DH sessions in Strasbourg, remain limited due to financial and staffing constraints. To address these issues and to close my statement here, the Bulgarian Helsinki Committee recommends, first, establishing a national coordination mechanism for execution with clear mandates and obligations for interinstitutional participation. Second, upgrading the DPR's institutional status, reforming its structure potentially by separating litigation and execution competencies and increasing its budget and staff. Third, introducing a single regulation or ideally a law to govern execution procedures and to reinforce binding effect of the convention by sanction system towards national bodies who fail to participate in execution. This legislation or set of legislations should cover the role of Parliament and the Constitutional Court. Fourth, strengthening parliamentary oversight and civil society involvement in the process. Fifth, ensuring regular training and international exchange for officials involved in execution, both in executive and legislative branch, which includes parliament staff as well. And sixth and last, addressing issues considered controversial that are central for execution of judgments with information campaigns and enhanced dialogue with other institutions where civil society organizations of affected communities are involved. The execution of judgments of the European Court of Human Rights is not just a technical matter. It is a measure of how seriously a state takes its commitment to rule of law. For Bulgaria, the road ahead requires both political will and administrative reform. It requires understanding that each unimplemented judgment is not only a line on a report, but a story of an individual whose rights were violated and whose judgment remains incomplete. Efficient execution is not an act of blind compliance with Strasbourg or violation of sovereignty. It is a reaffirmation of democracy itself. As the Roman lawyer and statements Cicero said, we are all servants of the law so that we may be free. Thank you.
Thank you, Radoslav. I will open the discussion here and feel free to give me a sign if you have a question. And while you're preparing your questions, I have first one question for Adam. From what you heard this morning on the general political situation in the country and what you heard now from Diana Marcheva and Radoslav Stoyanov on the non-existing working mechanisms for the implementation of judgments, how does the Council of Europe support national authorities in overcoming this reluctance? And are there effective strategies in place or examples of effective strategies for member states overcoming this reluctance for implementation? And how does it happen when you don't have the existing mechanisms and you don't have the political will to do it?
Thank you. Very challenging question indeed. And also I just wanted to thank the both the first panel and second panel, but extremely the second panel that gave a really good kind of idea of what it's like to live in a situation where it's particularly challenging to not have your same-sex partnership and family recognized. So I just want to thank those individuals for their stories. In terms of, I mean, I'll talk from the SOGIESC unit's approach to this, and what we, as the Council of Europe has already been mentioned, doesn't have the punitive measures as the EU. Political pressure is exercised through the Committee of Ministers, but what the SOGIESC unit can do is provide technical support for member states in terms of implementation. So, for instance, this has taken the form of, alongside the EU, supporting Albania in establishing its national action plan from 2021 to 2027 on LGBTI people in Albania. Technical expertise from the Council of Europe alongside, also involved bringing in civil society within that as well, and supported its adoption and throughout its implementation. As well as the legal opinion on the Ukraine draft law that I'd mentioned, there's also in Serbia there was a legal opinion on that draft law. Endorsement from the Council of Europe can support its passage through the legislature, but I think we can be certain it doesn't necessarily guarantee its passage through the legislature, and that depends on the political situation within the given country at that time. One thing that we found particularly helpful is through peer exchanges. For instance, when we were drafting a European report on legal gender recognition, which was published in 2021, we organized roundtables in Spain, Cyprus, Lithuania, and North Macedonia, all those different member states in different stages of that process. And in Cyprus, notably, with that, significant progress had been made in terms of establishing legislation based on self-determination. Whilst it hasn't yet been adopted, they've implemented administrative processes which do follow the self-determination model. So in terms of that ability of different member states to discuss with each other and share those experiences, considering different approaches, we do find that as a helpful mechanism, but obviously that requires the engagement of the member state. I think obviously awareness-raising activities are really important, such as through those aforementioned roundtables or conferences such as these, to raise awareness of the need to progress on certain issues and sensitize societies to welcoming efforts to support discrimination on SOGIESC grounds. In terms of different examples of where effective strategies have been used, I think, for instance, and I'll go back to the Ukraine draft law, so initially on same-sex partnerships. Initially there was a proposal to have a draft law that was called same-sex partnerships, had it all in one go, and that met some difficulties in one of the parliamentary committees there. And then civil society-backed alternative proposal approached it slightly differently through amending lots of different bits of legislation, not referring directly to same-sex partnership registration, but in terms of saying registered partnerships, just as that. And that's become a much more positive, it hasn't yet been adopted, but that's being treated a lot more positively in the Ukraine parliament. So it's also to do with the approach to the legislation and the approach to reform that can make a difference. Additionally, where full-scale legislative reform that creates rights and obligations in terms of same-sex partnerships that are immediately equivalent to marriage are not possible. An incremental approach has been helpful in some states. So, for instance, in Czechia, civil partnership regime that did not include a variety of aspects that were very aspects in terms of property and rights or pensions. For instance, that was adopted around in the 2000s. Then more recently, in 2024, there was an amendment to the Civil Code that created a form of partnership regime which is almost equivalent to marriage, notably doesn't have parental rights, but there was significant progress made, so it's also a case of starting something and waiting for a bit longer to see how that, to reach a better level. I think one example that we saw in Romania in terms of a positive campaign that was mainly run by civil society indeed, was the call to boycott the 2018 referendum, which would have installed a constitutional ban on same-sex partnerships. And that used an approach based on personal stories and parents supporting their children, and successfully that referendum was particularly boycotted and didn't pass. That requires a very vibrant and alive civil society framework within the member states. And unfortunately in Europe at this moment we are seeing attacks on civil society, for instance in terms of anti-propaganda laws and funding issues and those kinds of things that are creating a more difficult space for civil society. Sorry, not a super positive picture there, but again it's an area to be working on. And I think the last thing that I'll just mention on that point, and I think it's important to keep in mind that you can progress and reach a positive change, but then that change also needs to be defended. So for instance, in some member states where we've seen that we've reached a state of the positive state in terms of same-sex partnerships or legal gender recognition, things can change. And the third report on the 2010 recommendation showed that whilst there had been some progress, there's also been stalling, and then also in some cases regression in protections, as I mean we've also kind of discussed today. So again, that's sorry to end on a slightly negative poem, but I think the need to maintain momentum it is there.
I think Esther Pulgari had a question. When you mentioned rollback, I give the word to Esther.
Thank you. Thank you. And my question goes to Adam, I think. So we are suffering with the implementation or the non-implementation of judgment. And so we have a case from 2021, Rana versus Hungary. We also had a constitutional court decision in the case. It's under an enhanced procedure before the Committee of Ministers. We regularly submit every single year in the summer a Rule 9 submission to the court. The group of cases is growing as new cases on legal gender recognition come out. The language of the Committee of Ministers gets a little bit stronger every year. So they are not just concerned, they are deeply concerned or very, very concerned or something like that. But then eventually the result is that the government gets yet another year for submitting a new action report and nothing changes. And I'm just wondering what is the point, or do you have any idea what is the point where the Committee of Ministers, for example, triggers Article 46, I think paragraph 4 maybe, I don't know the paragraph number, so the infringement procedure for non-implementation of judgments that you used already, or they used already in case of Azerbaijan, I think, and Turkey. So, because it's just every year, and the year is a lot if you have to live in a country where your gender identity is not reflected in your papers. And I'm just wondering if you have any tips that we can use in order to get the Committee of Ministers in stronger action. Thank you.
I think there's no one easy answer to that, and I think you're aware of that indeed, but obviously it's important to make the point. There's work that we're some work that we're doing now with civil society, and going to be proceeding forwards with the European Implementation Network. They're a very helpful organization that supports and on the execution of judgments. And so I think it's about developing cooperation with them. It's about also engaging with the Committee of Ministers as well as through the Rule 9 submissions, but also through meetings and engagement that they help facilitate. So I'm not going to give you there's not a magic answer to say, okay, it's going to be done. It's continual engagement with them, keeping it high on the agenda. And obviously you do see the change in wording. That is a positive thing. It's not the result. But there's an acknowledgement that there is a progression towards the need to more urgently act. So I'm sorry, it's probably not the answer you were looking for, but I think it's the, yeah. Yeah.
I will repeat myself from earlier today, but I think we need more holistic, like multiple sides approach to this. And yes, interim resolutions and infringement procedures, they're something that might be wanted at some point. But I think that we should also encourage institutions of Council of Europe, this being Committee of Ministers, but also other institutions like Venice Commission or the Commissioner of Human Rights, to start thinking and be proactive in not in just using the stick, but also a carrot, like fostering dialogue, inviting constitutional judges to conferences, going with the conferences to the constitutional judges who do not go to the conferences, and you know, put an effort, maybe together with academia, into nurturing a culture of observing international obligation, of educating younger generation of lawyers, potentially future constitutional lawyers or Supreme Court lawyers or parliamentary experts or experts in the national body responsible for the execution of judgments, to have dialogue with their colleagues and delve into the culture of observing international obligations. So not just the top-down approach, but also bottom-up approach from both sides. I think only through this double-sided approach we have any hope of holding up in this international situations, situation where the reality is that actually truth doesn't matter really anymore. Law matters less and less. We are on a downhill, and we should be very frank about it and be more complex in our approach, because the problem is really complex.
Very positive, indeed. With a little bit of trying to not be as negative as we all maybe are, I have two combined questions to Diana Marcheva. How does the current legal framework allow bills to be proposed without proper checks against European Convention of Human Rights obligations? And what are the consequences for the rule of law compliance in this regard? And from a constitutional perspective, what reforms or safeguards could strengthen the accountability of the legislative and judicial branches in the implementation of judgments?
Well, the answer is very simple. Just adding in the law for the normative acts the same obligations for the MPs to have an ACHR compliance review before drafting a bill and actually submitting it. It's quite simple. If they don't have a political will to advance the rights of the LGBTQI people, they can they can explain it with the public opinion whatsoever, but how they will explain with the public opinion just having this big loophole in the existing legal framework. They don't have it. They don't. The MPs don't want to change the law because it will be more restrictive towards themselves. But one of the issues is that the international mechanisms work in a formal diplomatic way, and they cannot outrightly and directly point out such issues in order not to stop the dialogue with the governments. And but at the end of the day, if we don't acknowledge the loopholes in the legal framework, in Bulgaria we have a lot of them, we won't be able to actually point out what needs to be done. I mean, but in order for them to change the law, they have to have a pressure from the public. And but in the public we don't engage in such discussions. In Bulgaria, actually, it's impossible to even engage the legal academia in these discussions. We know among ourselves that the legal academics do not want to spoil their relationships with MPs or the judges, so they don't get into such criticism towards them. And it's just a few of us who are actually trying to point out the issues, and it's a pity that we cannot engage in a real deliberation for informed policy making and for actually trying to work on to have a dialogue even with the haters. And the last at one of the discussions in a parliamentary commission regarding the changes in the educational law, there were some students from the schools, and the MPs actually attacked these children, these proactive children, publicly, shaming them for having a stand on the law which actually regulates their own education. And it was accepted as something normal. There was no reaction towards this. And if we don't have a reaction on any kind of issues, even concerning children, what to say about the LGBTQI, Roma, or people of disability, or any other vulnerable groups' rights? It's actually, how to say it? They don't want to participate in any kind of discussion. They're not here. The ones who should be here, they're invited, and they don't want to come because they don't want to hear what all these issues. That's it.
Thank you, Diana. And one simple question to Radoslav. From a civil society perspective, which institutional deficiencies are most critical to address in order to improve compliance? I mean, and I'm not talking about Rule 9 submissions, except Rule 9 submissions that I think we all do. Like, what else can the civil society, can the general public do in order to support the process?
Well, both civil society and Council of Europe, we can together do one important thing. If we are having a bar fight, where on the one side it's NGOs and Council of Europe demanding observation of international obligation, and on the other side is a rogue member state, we should bring friends in the bar fight. This includes European Union, which has purely financial means to address such issues. You know that the Charter of Fundamental Rights, for example, is bound in its meaning to the European Convention of Human Rights, and non-observation, non-execution of judgments of the European Court of Human Rights should matter to the European Union. We should bring United Nations to the table because they also have treaties. Some of these treaties cover similar issues, and in some occasions, a failed case before European Court of Human Rights can be observed by the Human Rights Committee. So whether their opinions are executed then, and whether international obligations under the cap of UN as well are observed, also matters to UN. And if you don't execute European Convention of Human Rights or the judgments of European Court, this is of concern of the United Nations. And then we should bring, I think, Organization for Security and Cooperation in Europe. One of the three pillars of these organizations is the human dimension, which includes human rights, as means of securing the peace in Europe. And this non-execution and non-compliance with international human rights obligations should matter to them. We should bring friends in this fight because when all of those international institutions start to talk on the same, are on the same page and start to talk the same things, which is not the case right now, this will get involved more complex structures of the government and will raise the issue internationally much more than it is raised now. So this is what we can do as civil society organizations, because we have our own mechanisms, we have our own pathways to those international institutions. But if I were Council of Europe, I would do that as well, because institutions can hear from time to time civil society organizations, oftentimes, but though they can close their eyes. We can see that in the rule of law report of the European Commission, to be honest, which is another problematic topic for another conference. So international institutions also calling for help, I think, is quite important.
Thank you, Radosław. Does anyone have any questions? Please be brave.
Or solutions.
Yeah, go for, just for the recording, I'm sorry.
I was wondering, listening to, I don't know if it's a solution, probably not, and you probably thought about it, but listening to Radi in particular, and based on the study that you guys did at the Bulgarian Helsinki Committee, it seems to me that it's not just the issue of LGBTI, well, LGBTI-related judgments that are not implemented, and then compliance with new legislation, of course, also doesn't only refer to that. So I wonder if we can broaden the coalition of organizations that are really interested in pursuing that, and yeah, try to find also other partners in civil society which can push for that. We've tried to build, of course, a lot of intersectional coalitions, but maybe not so much onto the implementation side of judgment. And this made me also think, and it's a question, of whether or not really they don't want to deal with this, meaning they're really reluctant to implement suggestions, or they really lack the support capacity.
They don't want.
They don't want to do it.
They don't want.
Okay. Well, sorry.
That's the answer.
Okay, so we have to make them do it. Yes, very good.
Like, sorry for taking the word, but once again, in the beginning of this year, the Parliament explicitly adopted a legislation to not execute a European Court of Human Rights judgment. There was a court decision of the domestic Bulgarian court following, like, reopening a case following a judgment of the European Court of Human Rights, and reacting to media publications about this Bulgarian court's judgment, the Parliament explicitly adopted a legislation to undo it and to basically erase the result of the European Court of Human Rights judgment. This is malice. This is more than not willing to do it. This is willing to do the opposite. And this is a whole new level. Sorry, I didn't want to do that, but the eyes.
No, yeah. I just want to finish the conversation in a bit positive direction. And I will ask you, and if this wasn't difficult for you, my next task will be maybe a little bit more difficult. What can we do, and how can we make the situation work? What can we change, and how we can change it? I mean, I know it's but I just want to finish in a positive note, that there is at least a little bit of hope.
I'll be very brief. Like I said already, okay, I didn't say exactly this, but most people are not evil, and they're mostly not that stupid as we might think. So if we sit with them on a nice little tables like this and talk until we achieve some cultural change, things can go in another direction. I firmly believe in this. This is a slow process. This is a long run, for sure. But fostering dialogue among judges, among prosecutors, among public officials, maybe parliamentarians as well. We just heard that some parliamentarians do not even know what the execution mechanism is. Fostering this culture, especially in the experts that work in the parliament on daily basis with MPs, because MPs change every 4 years, presumably, sometimes even more often, preparing the people who are there constantly for educating the others, I think this could bring a change. Otherwise, getting more sharp in the words of Council of Ministers might lead to something, but might lead to what happened to Russia.
Yeah, but first you need to educate the educators.
True, that as well. Again, thinking of what could happen, Russia is a good example. If people don't care because you don't have a power leverage, they will not care. They will do whatever they want, and they will double down even. And what's happening right now with nuclear tests even is quite clear sign that we should do something different from sharp words in statements.
Yeah. Janko Grozef at noon told me that the constitutional judges do not have a dialogue among themselves. And if we are actually in such an institutional framework, because that's what happens in Bulgaria, even lawyers, the highest level of lawyers cannot have a discussion on legal issues, on constitutional issues among themselves. What is left to the parliament and all the rest? And the problem is that I didn't know that. I myself didn't know that. We don't know many of these actually intrapersonal issues within the institutions, and we assume that the institutions are working as they should, but they are not. And in my opinion, we should start with that. We should say all the institutions do not do the work they are supposed to do in the way they are supposed to do, to bring forward any kind of deliberation, because that's what is expected from the Constitutional Court, political deliberation from the Parliament. And even the judges, the Supreme Court judges, they themselves cannot have a proper deliberation on issues, and we should start from there, from my point of view. Okay.
I'll just finish on one point, and it's been mentioned already that the Council of Europe in itself is not only the execution of judgments. There's a plethora of different levels to engage with: Congress of local regional authorities, Parliamentary Assembly, the Commissioner for Human Rights as well. So I think it's engagement with the entire ecosystem of the Council of Europe that can push for change in other ways as well. So I'd say obviously it's really important that we maintain pressure on through the Committee of Ministers, through the execution of judgments, but through the wider engagement as well. Hopefully we can deliver some changes as well through that as well. So finish with that.
Well, thank you for the three speakers. Thank you for your patience and for trying, all of us, to find a way out of what I would call political crisis. Maybe before I finish, there is one question. Go on.
Hello everyone, I'm Kaloyan. I have a LGBT foundation in Plovdiv. I have it's a question and maybe a very provocative opinion on how we can maybe change the narrative. It's connected with our very famous lack of critical thinking as a nation, and that connects with the amount of ignorance we have on topics which don't concern us. By us, I mean the general public. And I think if we use these strengths as a weakness, and the same way someone doesn't bat an eye if they vote something about the agricultural laws in the parliament, half of the nation doesn't care because it doesn't concern them and because they cannot wrap their minds around that everybody of us is connected. Maybe we can use a similar strategy. Apart from we want to be included, we know we are together in this earth and we have rights, but if we distinguish LGBTQ people in the topic of the conference and we say not how their rights are connected with the other people's rights, but we distinguish LGBTQ rights as something that doesn't quite bother the everyday lives of people, and let's say we vote on something that doesn't concern you in any way, as the same way we do votes for disabled people, we do votes for stuff in our laws, in our economy, that if you are not so educated, you will not see the point at which concerns you. So if we kind of distinguish the narrative when things like LGBTQ rights are voted on and how they are communicated in the public with the representatives, is this a way you see possible to change the narrative of public opinion? I don't know if I explained the flow of my thinking correctly.
I think it is a way, like, way long years before I started doing law and human rights, I was in marketing. And what I learned, if I learned one thing, okay, I learned two things from marketing, three things, but one of the things was tests, and if you fail, then it doesn't work. So it's worth trying, of course. Solidarity is certainly a thing that we should be looking for in general, which means, yes, LGBTI issues are important, but as we already established and as you already concluded, the issue here is not just LGBTI rights. There is a toxic, I don't know about gender ideology, but there is a toxic ideology of non-compliance with international obligations, of we can do it on our own. This is pushed by a small group of influential people who want to keep their influence on societies. And unfortunately, this is the only narrative that reaches people, because they also, of course, have the resources, media resources and other kinds of financial resources, certainly. But we need to change this culture. We need to tackle this culture, and solidarity and empathy with other groups as well is certainly a way to achieve this. So that's a positive thing.
So what I will take from this conversation are several things, and I hope that you will take these several things with you back home and you'll think about them. The first one is no matter how the mechanisms are not working, we need these strategic litigation cases, because once we have the political will to change the situation, we will then have this the legal ground on place in order for the politicians to base their legislative actions. The second thing I will take from this conversation is we need more solidarity and more cooperation among the civil society and among citizens. And as you see from this conversation, the problem for the non-execution of judgments, no matter European Court of Human Rights or Court of Justice judgments, is not only regarding LGBTI rights. It concerns the whole Bulgarian society, and it concerns the whole Hungarian society, and it concerns all of these conservative societies around Europe that are trying to backslide the essence of our democracies and the core of our democracies. The third thing that I will take, and I hope you will take, is that we need more academic speaking, and we need academia to talk about human rights issues as part of the whole dialogue of rule of law, and to shift the judiciary and executive branches in the member states, because we alone as a civil society cannot move this conversation forward. So thank you for the speakers, for your time, and for the research you've done before this conference, and thank you all for being with us today.